It's early in the
I'm
morning.
going to jail.
Yeah.
But I have to go pick up my son.
Okay.
Like what?
Is there anything else?
Your Honor, when you said it's going to be this week, what,
What does it mean? So I'm going to jail?
Wednesday.
and if.
I'm going
and
to jail?
Wait a minute, I'm trying to find that. Okay, so.
State versus Amber Cortez. Can I have
To be
parties
dismissed,
announced?
but I'm not dismissing it upon your representation.
And are
Thank you
you,
very
Ms.
much.
Cortez?
Preliminary examination
Counsel
in
the
this
court
matter
admonishments with
will
your
be
attorney.
set
Did you understand it and sign
August
it in all the
19th,
appropriate places?
2025.
All right. You're charged with assault of a
12
peace
noon.
officer or judge as a second
That
degree
is
felony.
before
Range
me.
of punishment is anywhere from 2 to 20 years in prison and up to
on
$10,000
that
fine.
date.
If you have a plea with the state, the
For
court does
both of
not have
these
to follow your
cases.
plea. If for any reason the court does not
I
follow your plea and
will
gives you more than you bargained
apprise
for, the fact
the
that you entered a plea will not be used against you and you will be
parties
allowed to withdraw
also
your plea. Did you understand?
one
Review the
of
plea bargain
the
page with your attorney. Did you understand it?
I will
According to the
call
plea,
it one of
punishment is to be
the
assessed at
activities that I
5
think
years
it
in the
is
prison.
a
There's a $1,000
maneuver
fine to be
to
probated.
have
The
the
state
court
recommends
do
community
something that it
supervision. Did you
normally
understand
would
that to be your
not
plea?
do.
Yes, ma'am.
Defense?
The
State
defendant has
inside the agreement.
elected,
The state is recommending that your community
and I will
supervision be for a
disclose
term of
it
5
to
years. There be 100 hours
file
community
a
service restitution, no contact with Ingram Park. You
civil
understand those are
claim
recommendations from the state, and
as
the court does
against
not have to
me
follow those
and
recommendations.
a slew
Then to
of
the
other
offenses charged, how do you
parties.
plead? Guilty, not guilty, or no contest?
Oh, yeah, in that regard,
State
Your
any
Honor,
evidence.
Many of those do not.
No objection.
All right. And state, have you speaking
Including
to the
many
complaint?
that I don't
All right,
even
you
know
may
the
be excused.
connection.
Court will
has
accept into evidence states
this
exhibits 1 and
judge,
attachments to
if
the
on
court will review the
receiving
same.
this, two things. I read through the complaint
All right,
to
after reviewing
determine
states
whether or not
exhibits
it
1 and
put on
attachments, the
its
court will
face
find
create a
there's sufficient evidence to
court.
find you guilty,
I consider it, quite frankly, to
and the
be
court will find you
frivolous.
guilty. Are we proceeding with sentencing?
Plain itself.
Anything you
Do
wish to say on
not
behalf of
see
your
that
client?
as a necessity for
Yes, Your Honor,
me
my,
to accuse
client,
myself of
has
this
made some
gentleman's
mistakes in
proceedings
the past,
because I think
and
that's precisely
reflected
what he wants to have happen.
His criminal
And
history, and it's
attempted
also reflected in
He
these
will be
charges.
dealt with
Since
by
I've
me as
known
I
her,
would
I've
deal with any
met her,
other defendant. And
at
so
least 9 months ago.
that
She's
is
turned
there. It
around
has been
a
turned
lot,
over to the Office of
and
General
she,
Counsel for Washtenaw.
has
For
just had
Washtenaw
a
County,
newborn
they
baby.
will deal
She's
with for
3
me
children.
and as well as
She's
the
a single
others that
mother,
I see
and
that are
she's-
listed there.
I can see her doing all
They
she
will
can
deal
with
with
the
that.
help
They have
of her
also
family,
filed,
raising these children
it
and doing what she can
appears,
to support them. Your Honor, I
and
asked, I
again,
know
this
it's
is all
outside
part of his, what I will call shenanigans to
plea
shape this.
agreement was
He has filed
agreement
against
for a
people,
5-year. We ask you to consider making
individuals
a 4-year term
without specific
supervision.
reference
Figure in that time she'll either make
in the
it,
Washtenaw County Prosecutor's Office.
and that's all.
I don't, as I
Well, I have a
view
question for
what
you.
I read, would not consider
When you're
that
drug tested today,
any
what are the
jeopardy upon
results
their
going to be? And I'll tell you right
objectivity
now, if
in
your drug
this
test is
case.
negative,
So,
then I will sentence you to a length of probation that's 4 years.
It's gonna be 30 I'm on for now from the hospital.
At this point,
sorry,
we
what?
continue
I'm
to
on
pursue
high
this case
school in the hospital. I just had a baby.
until I hear otherwise.
And that's all it's going to be positive for?
I
Can I
have
speak
my,
on that note, Your
my
Honor?
documents, sir.
I will let you talk, but I'm not gonna let you go on in some diatribe. I've got
Oh,
other
no,
things
it
to
would be
do.
a drug
I've
test.
stood on my rights and I've stood on my
Well, the
beliefs this
5 years
whole
would be
entire
fine.
time, especially in the previous case, Your Honor.
So,
That complaint is well
let's do a
pleaded.
drug test today.
It does
did you
affect
arrive at court
multiple
today?
parties
And,
of this jurisdiction.
Okay, then she can get her drug test
Washtenaw
today and
County
I'll
is
come
a
back
named party,
with the
and I do
sentencing
believe
and
that my
we'll let
um,
them know what medication she says she's
impartiality
going to be on.
and
There should
bias
be nothing else
will
in
be
her system.
affected here, as it was in the
All right,
past, before this complaint.
Ms. Abrams?
And I do request
Oh, no,
a change of
oh, no,
venue
you won't have to pay
on
for
that
it.
note
Ms.
for both
Abrams,
these matters.
let's get her a drug test
Wish to
today.
raise change of venue, you may file to be dismissed, but I'm not
Now,
dismissing
let me
it
ask you
upon
this
your
before I send you
representation.
for the drug test.
Thank you very much,
I don't want
Preliminary
to-
examination in
Why
this
not?
matter will be
Why not? It's
set
free.
August
I
19th,
just do it.
2025,
No, let's do a drug test.
12 noon. That is before me.
Okay, unless there's something you want to tell me before I
On
send you to
that
go do your
date.
drug test.
For both of these cases. I will apprise the
For what?
For methamphetamine.
All right,
parties also
that's where we
that
are.
one
I
of
got
the
drug and someone
I will call it
No,
one
no,
of
no,
the
don't do
activities,
this
and I
thing where
think it
somebody's
is
mixing drugs
a
for you.
maneuver
No,
to
they
have
put-
the
they told me
court
something was
do
nothing,
something that
and
it
it was-
normally
No, no, no,
would
no.
not
You're
do.
not taking meds.
The
You're telling me.
No, I know,
defendant
I
has
am taking-
elected,
No, but here's the thing. You're telling me you just had a
and I will
child.
disclose
And
it
she
to
shouldn't be out partying
file
with other
a
people. She should be taking care of her child. So who is actually taking care of
civil
your child?
claim
No.
as
When
against
you were
me
out
and
using
a
drugs, where was
slew
your
of
child?
other parties.
I'm with my mom.
Oh, yeah, in
So-
that regard, Your
I
Honor,
am
I'm
taking care of
Many
the
of
kids.
those do
So
not
mom's taking care of
interrupt
the
me,
children.
No, I am. I have custody of them. They're at my
No,
apartment.
here's the thing. Just because you
including
have
many
custody of a
that
child
I
doesn't mean
don't
that you're
even know
taking
the
care of your
connection.
child.
Court
And if you're
has
using drugs, you're not
this
taking
judge,
care of your
if
child.
I'm receiving this, two things.
With that-
I read
with that
through
in
the
mind,
complaint to
Your Honor,
determine whether or not it
proceed to
put
the
on its
5
face,
minutes.
create a conflict.
All
Or
right.
You sentenced
I
her today.
consider it, quite frankly, to be frivolous, plain itself.
No problem.
Do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen. And that is attempting.
All right. Court is going to find you guilty. The court will sentence you to 5 years in the prison, suspended and probated.
Defendant, and so, that is there. It
For
has been
6
turned
years.
over to the
There's to be
Office of
regular
General Counsel
reporting
for
by
Washington.
Zoom or in person. And
Washington
counselor, if
County,
she
they will
completes
deal
everything
with
early, I'll
For
consider early
me, as
termination.
well as the others that I see that are
There's going to
listed
be
there.
proof of employment
They
within
will deal
45
with that.
days.
They
No
have
employment
also
as a home health
filed,
care provider or
It
with minor.
appears, and again, this is
There's
all
gonna be a
part of
referral to
his,
felony
what I
drug
will
court.
call shenanigans to shape this. He has filed against people
100 hours of
individuals
community service restitution.
without
I'm going
specific
to order parenting
reference
classes. How far did you go in school?
in the Washington County Prosecutor's Office.
I got a medical bill.
I
Sorry,
don't,
what?
as
I
I
have a medical
view
bill
what I
for me.
read,
All right,
would
there'll be
not
50
consider
hours
that
deducted.
any jeopardy upon
upon
their
completion of
objectivity
parenting
in
classes.
this case, so.
There's to be no contact.
I'm aware of such.
Ingram Park Mall.
Such filings were received by our office maybe yesterday. At this point, we
Ramon
continue to proceed with
Ramos.
this case until
Devon
until I do otherwise from the elected prosecutor.
Vasquez.
can I speak on that note, Your Honor?
Why were
I
you
will let you
still?
talk, but I'm not gonna let you go on in some diatribe. I've got other things.
Honestly, I was just going
I've
through a
stood on
hard
my
time
rights and I've
living
stood on my
this
beliefs
outside
this whole
point in my
entire
life
time,
where
especially in
it's just,
previous case, Your Honor.
I could do it so much
That
in my life,
complaint
to
is
be
well
honest, and
pleaded.
it gets
Um,
hard, to be honest.
It does
I know.
affect
that still
multiple
doesn't explain to me
parties
why are
of
you not at HEB taking
this
items from them? I'm
jurisdiction.
not recommending you take it from them, but you were
Washtenaw
stealing from
County is a
Dillard's
named party,
department store.
and I do
What
believe
were you
that my
taking from Dillard's?
That's sure.
impartiality
Well, it was more than
and
just short
bias
because they said
will
they
be
would
affected
retrieve
here
items from
as
you.
it was in the
Just 2
past
shirts.
before this
Just 2
complaint.
shirts?
Yeah, they're
And I do
All
request a
right, so
change of
why are you taking
venue
polos?
on
And were
that
those
note for both these
female polo
matters.
shirts?
That's for my son.
If you wish to raise change
How
of
old is your
venue,
son?
you may file to be
Sitting, so-
dismissed, but I'm not
So why are you
dismissing it
stealing
upon your
Polo shirts
representation.
for.
Thank you very much, Judge.
Preliminary
I'm sorry, what?
examination in this matter will be set
I'm sorry, I can't understand.
August
for
19th,
Easter?
2025, 12
For
noon.
Easter, so her son looks
That
nice.
is
It was around
before
Easter.
me
All right, isn't Easter the celebration of Jesus Christ?
on that date for
Right?
both of these
So you think
cases.
Jesus would want you stealing?
I will
That's why I hadn't-
apprise
every time I
the
was pregnant. I had
parties
great
also
change in my heart. and
that
change in my-
All right,
one
is
of
Child
the,
Protective Services involved in your life?
No.
I will call it one of the activities,
they're
and
in
I
her
think
life?
it is
No, Your Honor. I
a
think-
maneuver
Because I will
to
tell you right now, I have
the
concerns
court do
because
something that it normally
she has a
would
child
not
with her
do.
and she's going to test
The
positive for
defendant
meth.
has elected,
The
and
felony
I will
theft course.
disclose it, to file a
Who stays with you?
Just me and myself.
civil
Well,
claim
who's with your children right now?
as
my
against
baby's
me and
My mom was sick
a
this morning. so I
slew
didn't
of
do
other
my kids.
parties.
Oh, my newborn. My kids are at
Oh,
school.
yeah, in that regard, Your Honor,
All
I'm
right.
Many of
Somebody
those
called
do
over and
not
have a
interrupt me.
caseworker come over so they can talk to her just for,
Including
I
many
don't know,
that
open the
I
case.
don't even know
But
the
you do need
connection.
somebody to
Court
help you out.
has,
I don't,
This
and
judge,
I've
if I'm
been really good
receiving
for the
this,
past 9 months.
You're telling me you're
two
positive for
things.
meth.
I
That's
read
not
through
being.
the
If something
complaint
put
to
in my
determine
drink,
whether or
yes.
not it
I was
put
around
on
the
its
wrong
face,
people.
create a
I was
conflict.
just went out for a drink
Or
and where it was at
I
my friend's house.
consider it,
and
quite
that's it.
frankly, to be
That's the first
frivolous,
time I hardly even go out.
plain
I don't go
itself,
out at all.
There's
do not
going to be
see
the
that
felony
as a
theft
necessity
course. There's
for
going to be a TAP
me to
evaluation
recuse
in
myself
custody.
from this gentleman's
Follow
proceedings, because
recommendations
I
of
think
TAP.
that's precisely what he wants to have happen. And that is
There's going to be
attempting
field
to
visits one time per month.
He will be
until
dealt
further
with by
notice.
me as I deal with any
Probation,
other
is there anything
defendant. And
else?
so that is there. It has been turned over to the Office of General Counsel for Washtenaw
Yes.
County.
And the
They will
felony
deal
drug
with
court and
for
custody
me,
counsel, that will
as
be
well
done
as the
this week
others that I
because
see that are listed
it's early in
there.
the morning.
What is
They
that?
will deal with that. They have also filed,
I have to go pick
it
up my
appears,
son.
Okay.
Like what?
and again, this is all
Your Honor,
part
just-
of
I
his,
just-
what I
when
will
you
call
said it's gonna be this
shenanigans to
week,
shape
what-
this.
What does
He
it
is
mean? So I'm
filing
going to
a
jail?
couple of
Wednesday.
individuals
Wait a minute. I'm trying to find
without
it.
specific reference
Like, come on.
in the
And then
Washtenaw
once
County
the-
Prosecutor's Office.
The felony drug court. is
I
done,
don't, as
then
I
She's
view
not
what I
ready to
read,
go home to
would
my
not
son.
There's
consider
$1,000
that
fine and that will
any
be
jeopardy
probated.
upon their objectivity
Please,
in
Your Honor,
in this
please.
case. So
You could dress
Probation.
every week and I promise I will come out.
Probation, is there anything
Such
else?
filings were being received by our office maybe yesterday. At this point, we continue.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement,
Can I
because I
speak on that
followed
note,
your
Your
plea
Honor?
bargain agreement, and because you waived your right to
I
appeal,
will
you do
let
not
you
have the
talk,
court's
but I'm
permission
not
to
gonna let you
appeal.
go on
Because
some
this is a
diatribe.
felony
I've got other
conviction, you're not
things to
allowed
do.
to own or
I've stood on
possess
my
any
rights and I've
weapons or
stood on my
ammunition.
beliefs this
If
whole
you have a
entire
question
time,
over what a
especially.
weapon or ammunition is, you'll need to speak to an attorney. All right, so
What we just witnessed is a powerful example of how quickly a courtroom hearing can shift once credibility becomes an issue. At the beginning of this case, the situation actually looked somewhat favourable for the defendant. She had already negotiated a plea bargain with the state, which meant prosecutors were recommending 5 years of community supervision instead of prison time. Considering that the original charge, assault of a peace officer, is a second-degree felony carrying up to 20 years in prison, probation was already a significant opportunity. But in court, opportunities like that depend heavily on honesty and cooperation. And the turning point in this hearing came when the judge asked what seemed like a simple question: what will your drug test show today? This question wasn't random. Judges frequently ask about drug testing when someone is being considered for probation, especially in cases involving theft, erratic behavior, or a criminal history. The court wants to know whether the defendant is actively struggling with substance abuse, because probation requires strict compliance with conditions like drug testing, counselling, and regular supervision. At first, the defendant suggested that the only reason a test might show anything was because of medication from the hospital after giving birth. But when the judge pressed further, the story began to change. Suddenly, she admitted the possibility of testing positive for methamphetamine, a very serious admission in a courtroom setting. From the judge's perspective, this raises multiple red flags. First, substance abuse can undermine a defendant's ability to comply with probation conditions. Second, the defendant repeatedly attempted to shift responsibility by suggesting someone may have mixed something into her drink. Courts hear explanations like this frequently, and judges tend to view them skeptically unless there is clear evidence. The judge then focused on something even more important: the welfare of the children involved. The defendant had just told the court she recently had a newborn and was responsible for several children. But if she was using drugs, or even spending time in environments where drugs were present, that raises serious concerns about stability and safety. This is why the judge mentioned Child Protective Services, not necessarily to punish her, but to make sure the children had appropriate support and oversight if needed. Another striking moment came when the judge questioned the theft itself. According to the discussion, the defendant had been stealing polo shirts from a department store, claiming they were meant for her son for Easter. The judge responded with a pointed question: isn't Easter the celebration of Jesus Christ? Do you think Jesus would want you stealing? That moment highlights something important about courtroom dynamics. Judges often use moral reasoning to challenge defendants who attempt to justify criminal behavior with emotional explanations. While financial struggles and personal hardships can be real, the law still requires accountability. Ultimately, the judge accepted the plea agreement but imposed strict conditions. The defendant received 5 years of prison time suspended, meaning she avoids immediate incarceration, but must complete 6 years of probation under supervision. On top of that, she must complete drug court programs, parenting classes, community service, employment requirements, and regular check-ins with probation officers. Any violation could send her directly to prison. So in many ways, this sentence represents both a warning and an opportunity. The court has made it clear that the defendant's future depends entirely on her ability to follow these conditions and demonstrate real change. Now here's the question for you. Do you think the judge handled this situation fairly? Should the court have been stricter given the drug admission and the children involved, or was probation the right choice to give her a chance to turn things around? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.